damn racketeer and a damn fascist, adding, for good measure, the whole government of Rochester are fascists or agents of fascists. They then arrested Czaplinski under a state law that prohibited anybody from addressing, quote, any offensive, derisive, or annoying word to any other person in a public place, or calling the person, quote, by any offensive or derisive name. Wow. What does that do to your First Amendment freedom? Can't say anything offensive to somebody in a public place. Well, the Jehovah's Witnesses took the case to the Supreme Court, which decided it in 1942, upholding the conviction of Czaplinski. And the court reasons that there, quoting the court, there are certain well-defined and narrowly limited classes of speech, the prevention and punishment of which have never been thought to raise any constitutional problem. These include the lewd and the obscene, the profane, the libelous, and the insulting or fighting words, those which by their very utterance inflict injury or tend to incite an immediate breach of the peace. Such utterances are no essential part of the exposition of ideas and are of such slight social value as a step to truth that any benefit that may be derived from them is clearly outweighed by the social interest in order and morality. Thus was born the so-called fighting words exception to the First Amendment. Notice what the court's doing here. It's saying that there are certain classes of speech, certain categories of speech that are completely outside the umbrella of First Amendment protection. And by way of example, they refer to obscene speech, obscenity, a subject about which we'll have more to say. Incitement, of course, we knew about that from the Brandenburg situation. Libel's not protected by the First Amendment. There are these categories, which the court says are of such slight social value, categories of pure speech, not conduct, not action, pure speech, of such slight social value as a step to truth. Remember, one of the rationales for why we protect freedom of speech is to promote the ascertainment of truth in a marketplace of ideas. But these categories, the court said, now including fighting words, have such slight value in the search for truth that they can be banned altogether. And this was really the first time that the court had attempted to define with any specificity one of those categories. It had always been assumed by the court, by the country, that obscenity, whatever it was not protected by the First Amendment, but the court had not arrived at a clear definition of what is obscenity. Similarly, the court had always assumed, but it was just an assumption, that libel was outside the protection of the First Amendment, and never until New York Times versus Sullivan did it get down to focusing on the extent to which libel is or is not unprotected by the First Amendment. The test, I suppose, for fighting words, the insulting or fighting words, those which by their very utterance inflict injury or tend to incite an immediate breach of the peace. The standard is not very satisfying. The opinion in Czaplinski was for a unanimous Supreme Court, including Black and Douglas, the First Amendment absolutists. And the court took it as obvious, the court said, that calling a law enforcement officer a damned racketeer and a damned fascist, these were, the court said, epithets likely to provoke the average person to retaliation and breach of the peace. Not obvious to me, and you would think that law enforcement officers would have a thicker skin than most people and be able to ignore these insults. But as I say, the court's rationale was that fighting words bear no relationship to the search for truth and can be excluded from the marketplace of ideas because they're not ideas. They're fighting words. They're calling somebody's name right up in their face where you're likely to start a fight. And that's not protected. The court has never, since Czaplinski, since 1942, upheld the conviction of anyone for having delivered fighting words. Instead, the court has gradually, over the years, restricted very narrowly the fighting words exception to the First Amendment. Take an example, the famous case of Cohen versus California, which involved during the Vietnam War, and a young man by the name of Cohen went to the courthouse in Los Angeles wearing a jacket that said, "Fuck the draft," on the back. And he walked into the courthouse with this jacket, mingled with the people, went into a courtroom, took the jacket off before he went into the courtroom. The bailiff had seen the jacket and warned the judge that he had this, and the judge refused to evict Cohen from the courtroom. But the police arrested Cohen for disturbing the peace under the California disturbing the peace law, and his case worked its way to the United States Supreme Court during the Vietnam War. And Chief Justice Berger was a very not only pompous and rigid kind of guy, but he was approved as well. And he was highly conscious of what the crime allegedly was in this case. And so he cautioned the lawyer for Cohen when he stood up. The court assumes that all the justices have read the briefs and they're well aware of the fact and so on. That's no news. But Berger took it upon himself in calling the case to say the court is very well of the facts, and it will not be necessary to dwell on the facts in this case, thinking that uttering that word would somehow destroy the decorum of the courtroom. And so the lawyer stood up and to his everlasting credit said, "Mr. Chief Justice, and may it please the court, my client, Mr. Cohen, wore a jacket into the Los Angeles Superior Court House bearing the legend, 'Fuck the draft.'" And that was exactly the right thing to do. Not to pussyfoot around about it, but let's talk about what's really at stake here. And the court, over a dissent by Berger, decided that Cohen's activity, wearing the jacket with the slogan in a courthouse, was protected speech. Notice, they didn't say a word. It's the symbolic speech doctrine that originated with Stromberg that protected him. But the court said in the Cohen case, this was an opinion, a wonderful opinion by Justice John Marshall Harlan, a conservative justice, but one who was very principled. And he said, you got to look at the context in which fighting words or any speech are uttered. You can't just pluck out these words and say that these words are in some kind of banished category of speech. You have to look at the context in which they're uttered. And Justice Harlan said, surely the state has no right to cleanse public debate to the point where it's grammatically palatable to the most squeamish among us. So Cohen narrowed the fighting words doctrine in two ways. It required consideration of context, which the court didn't consider in Chaplinsky, and the court said that the fighting words must tend to provoke violence by the person addressed, the person in whose face you are screaming the fighting words, not violence by an unruly crowd, by the listeners. The fact that you upset listeners by your speech is not a basis for curtailing speech. Speech that might cause unrest is certainly protected. And since Chaplinsky, and over the decades, the end of the 20th century and up until now, the court has sort of consistently narrowed the categorical exceptions to free speech. The court really doesn't like a categorical approach to deciding these cases. Either it's protected because it's in this category, or it's unprotected because it's in that category. That isn't the way the court likes to decide cases. They like to balance the interests, identify the interest on the free speech side, the government's interest on the other side, find out whether the interests are better served by a restriction that's more narrow, and so on. Not just simplistically decide, well, it's in one category or another. That's deceptively easy to do and doesn't require any close attention to the facts. And the categorical approach is not now in good repute. For example, fighting words. The court hasn't touched that since Chaplinsky. The court keeps saying that fighting words are a category of unprotected speech, but there's no evidence that the court is about to expand that category, whatever it is. Obscenity used to be, people thought they knew obscenity when they saw it, but they had grave difficulty identifying it legally, and that category of obscenity was whittled down, in case we'll talk about it in a minute, so that it now only affects hardcore, I mean really hardcore pornography. Libel was whittled down in the New York Times versus Sullivan. The court in the child pornography case that we'll consider toward the end of the course threw out the government's notion that virtual child pornography, computer-generated images, were themselves a category of unprotected speech. Wouldn't buy that. And then just recently, with the Roberts Court, we get the Stevens case, which also involves the government argument that here's a category of speech, like fighting words, like obscenity, like libel, that doesn't enjoy any protection. It involves a federal law about depictions of cruelty to animals. And what animated this law, apparently, is the emergence of what are called crush videos. You guys know what a crush video is? No? Well, it's sort of like this. I mean, you can find them still on the internet. They are pretty gross. They usually involve a beautiful young woman in stiletto heels and a mouse or a kitten or a bird or some little helpless animal that is crushed to death by the stiletto heel. You gasp. Apparently it appeals to a certain sexual fetish, and that accounts for their existence. Well, Congress said we don't want any crush videos allowed, so they enacted a law that made it a federal crime to distribute for commercial purposes depictions of animal cruelty in which a living animal is intentionally maimed, mutilated, tortured, wounded, or killed. Watch those last two. And then the Congress included an exception to the prohibition, a savings clause, saying that anything that has serious religious, political, scientific, educational, journalistic, historical, or artistic value is not prohibited. And the structure of this law is reminiscent of the definition of obscenity that the court finally settled on in Miller versus California in 1973. The court had struggled for decades with defining what it is that is obscene and therefore not protected by the First Amendment. The court had watched dirty movies in a screening room in the Supreme Court. The court had read dirty books. Dirty books, Lady Chatterley's Lover was one of them. I mean, some works of good, wonderful literature had been condemned by various states and localities, and the court had to rescue literature from condemnation by obscenity laws. Well, finally, in Miller versus California, the court undertook to define what it is that is obscene and came up with a three-part test. In order to be obscene, this material has to meet all three parts of the test. First, it has to appeal to the prurient interest, that is, the interest in sexual arousal. Second, the material must be patently offensive in its depiction of sexual acts, as judged by contemporary community standards. Patently offensive, as judged by contemporary community standards. And third, the material has to lack serious literary, artistic, political, or scientific value. At one point, the third thing the court had said means the material has no redeeming social value. And that slogan you still hear, but that's not the test. The test is no serious literary, artistic, political, or scientific value. So if it meets all three parts of the test, it's obscene. It can be banned in any medium of communication, whether it's a dirty video, or a television program, or a book, or Hustler magazine, whatever medium of communication. If it meets all three parts of that test, it's obscene and can be prohibited. The test is not very useful, and it's pretty unclear, and it's contradictory. It doesn't make a lot of sense, but that's what it is. Professor Kathleen Sullivan from Stanford has pointed out that the first two are really quite insistent. She says the appeal to prurient interest, that means it turns you on, which in colloquial language is about what that part of the test mean? But then the second one says it has to be patently offensive, as judged by community standards. In other words, it grosses you out. So at the same time, it turns you on and it grosses you out. But that's what the law is. And then there are all sorts of problems about whose community, what the community standards are, whose community are you talking about, and so on. But in any event, that's still the law. 1973, what's that, 40 years ago, right? And the government rarely attempts to bring obscenity prosecutions these days, sort of having given up on getting convictions, except in the rawest, ugliest, most awful kinds of depictions you can imagine, like rape scenes. You know, there's real serious, if you will, bestiality and really hardcore stuff. Playboy, hustler, naked people doing sexual things. That's all not treated as obscene these days at all. Well, in the animal cruelty case, the Congress picked up this technique, this legislative technique, of including a savings clause, like the third part of the obscenity definition, saying that if it's got serious, religious, political, it added a few more categories, then it's not prohibited, very much like the obscenity definition. Well, one hapless man by the name of Robert Stevens had collected some videos of dog fights, pit bull fights, and pit bulls attacking other animals. And he got some of the videos from Japan, where apparently dog fighting is legal. Some of them were older American dog fights, and some of them involved pit bulls hunting animals and so on. Okay?
I have a question about the safety test.
About what?
The test that we just previously looked at. Are those tests, I feel like one of the major problems with that is that it's written from two different points of view. So one, it's written from the point of view of, like, I really enjoy this, and, like, this is what I like to watch on the internet. But also on the view of, like, why should that be allowed on the internet? So it's like the you in that switches, right? So what is the viewpoint that these tests are usually written from? Because I feel like that's a weird, or do they usually have multiple viewpoints?
Well, it's the court that wrote this test.
Right. But it addresses, like, two different people who are viewing. Does that make sense? You know what I mean?
Yeah, they're from different perspectives.
Right.
Sure. Yeah, it turns you on. But the gross out thing is written from some different.
Other point of view.
Yeah. Nick?
You
You can say that this is your art, but there will be expert witnesses brought in. There will be art historians. There will be gallery owners who come in and say, this is a work of genius, and clearly is art. And then the other side, the government, will have experts saying this has zero artistic value, makes no contribution to our culture, and so on. And the jury is supposed to decide that issue, who they believe and trust, and so on. Well, Stevens had all these pit bull videos, and he sold some, as frequently happens in these quasi-pornography cases, sold some to a federal postal inspector online. The postal inspector posed as somebody who wanted to watch dogfights, and so Stevens sent him some videos, and he was then prosecuted, convicted, and sentenced to 37 months in prison. And he went to the Supreme Court, and the opinion was written by Chief Justice John Roberts. This was one of his First Amendment opinions, and he followed what is, this is a clip from one of his dogfights, I guess. He followed what is now familiar to you as conventional First Amendment analysis, that if the speech restriction is content-based, this one clearly was, it didn't restrict all videos, it restricted videos of depictions of animal cruelty, it is therefore presumptively unconstitutional. Presumed to be unconstitutional if it's content-based, casting the burden on the government to demonstrate that the restriction is justified by a compelling government interest, not important, not substantial, not significant, compelling government interest, and that the restriction is narrowly tailored to serve that interest. Well, Chief Justice Roberts struck the law down in his opinion, saying the statute violates the First Amendment. It's content-based, therefore presumptively invalid, and it's not narrowly tailored. Roberts didn't pay any attention, or certainly no significant attention, to whether the government had a compelling interest in suppressing these kinds of videos. I suppose you could argue that either way, but that isn't the focus of his opinion. Rather, he went directly to the narrow tailoring analysis and said that this law is not narrowly tailored to serve whatever interest the government is claiming to have here. The court concluded that the law was overbroad. Overbreadth is a basis for finding that a law is unconstitutional as a violation of the First Amendment. It's overbroad in the sense that it doesn't outlaw a particular kind